Bar Unlocked, and this video is part of our series going through modernized questions from the USPTO patent bar that were given in 2002, but have been updated to be in line with modern law. For this question, we'll be discussing what might happen if you want to file an information disclosure statement after a notice of allowance and the payment of the issue fee. So this question says, Registered Practitioner Joe files a design patent application under 37 CFR 1.53b, having one claim on May 6, 2024. The USPTO sends Joe a notice of allowance dated November 10, 2025. Joe pays the issue fee on November 15, 2025. On November 23, 2025, Joe learns about a publication, the Smith reference, which Joe knows to be material to patentability of the claim, but which was not considered by the examiner during prosecution of the application. Joe prepares an information disclosure statement that complies with the provisions of 37 CFR 1.98, listing the Smith reference. Which of the following actions, if taken by Joe on November 24, 2025, will result in a request for continued examination of the application being granted in accordance with the USPTO rules and procedures? So, this question poses an interesting situation. So the application has been examined, the applicant has received a notice of allowance, and has already paid the issue fee. Once all of these things have happened, the options available to the applicant are much more limited. Pause the video and read through the answers and see if you can spot the trick in this question. Which answer do you think is correct? Okay, now that you've chosen your answer, let's take another look at the question stem. The important clue is here. This is a design patent application. Options for design and utility patents to reopen prosecution are very different. For a utility patent, you can file a request for continuing examination, or an RCE. However, this option is actually not available at all for a design patent application. So this question is a trick question, and the correct answer is E. None of the above are correct. Now, one of these options is correct if we were talking about a utility patent. Can you figure out which one it is? Pause the video if you need more time. The correct answer if the question had been asking about a utility patent is C. Now, let's say you weren't sure and you wanted to look this question up. In this case, I would suggest going to the rules appendix of the MPP rather than going to a specific chapter. So let's do this. If we go to here and we look up a request for continued examination, and look, there's a whole section about it, 1.114. In mine, I can't click from the table of contents, but you'll be able to on the exam. All right, going straight here, we see that an applicant may request continued examination by filing a submission and the fee prior to the earliest of the payment of the issue fee unless a petition under 1.313 is granted. So the steps here for a utility application would be to have the petition, to reopen prosecution, to pay the fees, and to put in a request for continued examination while filing the information disclosure statement. Now, if you wanted to check and see if this would work for a design patent, here in Part E, it says the provisions of this section do not apply to an application for a design patent. Now, to kind of bring this full circle, what would you do for a design patent? In a design application, while you can't file an RCE, you can file a continued prosecution application or a CPA. So let's search that term and see if we can find out what the applicable rule would be. So that would be a application. And there's a rule under 1.53D, so we're going to go there. And here we go. It says application filing requirements for a CPA. And this says that the application must be for a design patent, and it must be filed before payment of the issue fee unless a petition under 1.313C is granted in the prior application. So again, this would involve filing a petition, and also filing the CPA with the appropriate fees. So, overall, the answer to this question is a trick question. It's E, none of the above. If the application had been a utility application, answer C would be correct. And if you were filing a design application, the process would be similar, but you'd be filing a continued prosecution application rather than a request for continued examination. Thanks for watching, and don't forget to like and subscribe to catch the next videos in this series, along with more patent bar tips, tricks, and practice questions. If you want to start with the basics, my free Introduction to U.S. Patent Law module and a 10-question sample quiz are both up at patentbarunlocked.com. See you in the next one!